Good morning, Remax Distinctive. Want to welcome everybody to our Maryland required monthly training for September. And we're going to jump right into our discussion today. Pardon my birds, please. They want to compete with me. This case is a discussion involving a listing agent's duties to their seller client, the MREC complaint process, the Maryland Guarantee Fund, and the administrative law judge's decision. The Burbacks, the sellers, alleged that Benson, the listing agent, actions during the sale of their property caused them financial loss due to the buyer's failure to assume Conservation Reserve Program contracts, which required the Burbanks to repay $43,851 to the U.S. Department of Agriculture. So Rodney and Joy Burback owned property located at 1747 Town Point Road in Cambridge, Maryland. The property was encumbered by a conservation reserve program, contracts, and a Maryland conservation easement. The special contracts between the USDA and the Burbacks provided special benefits for the USDA to use the land for agricultural purposes. So those were two factors that were tied to the transaction, but not necessarily tied to the land. The CRP contracts required the Burbanks to maintain 2 ponds on the property in exchange for annual compensation from the USDA. If the property was sold and the buyers did not assume the CRP contracts, the Burbanks were required to refund all USDA payments. The Burbanks and Benson entered into a listing agreement on November 27, 2020. The agreement did not include a requirement for the buyers to assume the CRP contracts. On July 29th of 2021, the Burbacks entered into a residential contract of sale with Richard and Don Huffman. A July addendum made the sale contingent on the buyer's review of conservation easements, but did not address the CRP contracts. A September addendum required the buyer to acknowledge the review of the contracts, but did not require the buyer to effectuate or be bound by them. So those are two separate issues. There is the conservation easement is one issue, and the contracts for the usage of the property or partial usage of the partial part of the property by USDA was another. The September addendum addressed prorated rents, but incorrectly stated that the CRP contracts run with the land. So the contracts were stated as being running with the land when in fact they were not running with the land. The property sale was finalized on September 27, 2021. The buyers later informed the Burbacks that they could not assume the CRP contracts due to their high income, requiring the Burbacks to repay $43,851.76 to the USDA. Charges against Benson. Benson was charged with violating bad faith and incompetency or untrustworthiness and failing to protect and promote his client's interest. So that was what was brought to the Real Estate Commission, those two charges. The Real Estate Commission and the administrative law judge who oversaw the hearing found that Benson did not act in bad faith or demonstrate incompetence, but failed to understand the CRP contracts and their implications. The Burbanks did not communicate the importance of the CRP contracts to Benson until after the sale contract was signed. The outcome, the charge under 17322B25 was dismissed, which covers the issue of engages in conduct that demonstrates bad faith, incompetency, or untrustworthiness, or that it constitutes dishonest, fraudulent, or improper dealings. The charge under 1732233, which was failing to protect and promote his interests of the interests of his clients, Benson was upheld. Benson received a reprimand, but no civil penalty. The Burbanks' claim for compensation from the Guarantee Fund was denied. So the reason for the denial of the fund claim was that the Burbanks' financial loss was attributed to their failure to communicate the requirement for buyers to assume the CRP contracts in a timely manner. Benson's actions did not directly cause the loss. So the consensus after reading all of this, and there's a lot more details to this case, so this is just a very brief summarization of it, but after reading all of it, why did the Real Estate Commission law judge uphold the charge of failing to promote his claim, the claim of interest, and his claim and interests? Do you have any thoughts on why the judge might have failed to uphold that? Excuse me, I'm sorry. Failing to promote his claim of interest for the failure of understanding the contracts. That's where they felt that he failed the client, was in the concept of not fully understanding the contracts and not understanding the importance of why they were so important. The Real Estate Commission and the law judge decided that they did not, that the sellers did not communicate clearly to the listing agent the importance of that, and he assumed that he understood the terms of those contracts, but didn't refer them to legal counsel. So the point here is, if he had referred the clients to legal counsel before proceeding with the sales contract and proceeding with the listing agreement, he would not have been held liable and reprimanded as a result of that. So that's the point of that. Instead, what he should have done was should have been to refer them to legal counsel, rather than to assume that the seller and he had full knowledge and understanding of those contracts. Do you have any thoughts on that, Shafiq?
So part of me says, you shouldn't do anything that you don't fully understand.
Yep.
And if he didn't understand the implication of an easement or the implication of that agreement, he should have asked for assistance.
Yep.
Before he proceeded.
Yep.
Or he should have asked more questions to the owner, that is this the only agreement that you have?
Right. And those agreements, those contracts, obviously written by fancy schmancy lawyers, are going to be quite complicated, right?
Yeah. And if they were complicated, then he should have said, you need to address this with an attorney as to if there's anything else that we need to put into the contract.
Exactly. That's exactly where they failed. Yeah.
Because he did acknowledge there is something, but he didn't fully acknowledge what it meant.
Exactly. Yeah. And so the sellers ended up eating that $44,000. So,
but I'm surprised the the judge sided with the agent on everything. The agent was at fault.
Yeah, I am. Well, they didn't side with that. They didn't side with the agent on everything. They did reprimand him. They did reprimand him for that. They did not say that his failure. What they decided was that his failure did not cause the loss. The loss was caused by the seller themselves by not articulating the importance of those contracts early on with the listing agreement, and early on before and during the contract process until the very end. And yeah. And so
I agree with that but I think there's a fiduciary responsibility on the agent to ask the question.
Exactly.
What are these contracts and what do they mean? And ask for assistance, and then maybe refer to something. For instance, in DC, there is easements, right? Building easements.
Yes.
that convey with the property, but those easements vary with who the easement is with,
Exactly. Yeah.
right? And you can't assume the easement to be, oh, it's just a facade easement. You can't do anything in the front.
Right.
It might be a whole lot more than just the front.
Exactly. Yeah. It's a good discussion.
Right?
Is there some place that the agent should have gone to, some kind of public record that the agent should have gone to, knowing that they are engaging with a property of this nature, where they could have looked these things up themselves?
No, I don't think that would have been the job of the agent to look it up. I don't think it would have been the job of the agent to look that up. I think it was the job of the agent to seek legal counsel, or to have the seller seek legal counsel and then get them clarification as to how they should handle those issues. This is not something that this is not, there is no, yes, the conservation easement in this particular case was not the issue. And there is legislation that covers where the conservation easement terms exist. But that really wasn't the issue of this complaint. It wasn't the conservation easement that was the issue. It was the contracts that were the issue.
So the onus is really on the seller to present these contracts to the agent.
Well, and then in turn, it was on the agent to insist on legal counsel and legal guidance. So the agent should have redirected his client to legal counsel to get further instruction from legal counsel. Yeah, and that's where the failure was. So good discussion. Any other comments, thoughts?
I have a question.
Yes.
When you're referring your client to legal counsel, I think you mentioned earlier, it is on the agent to figure out what needs to go into the contract.
Don't want to be pushy.
Right? And so then if that's on us to figure out what needs to go into the contract and we need to seek legal counsel for that, are we paying for that?
No,
As-
no, that would have been the seller's obligation. So the agent needed to refer the seller to legal counsel, and the seller's obligation to pay for that legal counsel.
Okay.
Yeah. Yeah. Yeah, we're not obligated to that. That's because we're providing our services, but that's not our responsibility to assume that cost.
Do you know if that would get caught in a title review?
No, because it probably wouldn't have, because the contracts did not run with the land. The easement ran with the land, but the contracts did not run with the land. And so there was nothing that was ever recorded on or based on those contracts. So it probably would not have been covered by title insurance.
Okay.
Yeah. Good discussion. Any
Again,
other?
is it up to us to say to a seller, are there any other contracts or what, or any other contracts that you are obligated to, that this property is obligated to? Like liens, like we ask about liens.
Well, I think it's not on us to I think it's probably a smart idea to do that, but I don't think there's an obligation for us to ask questions on that under normal circumstances. So this was really a failure of the seller to not really mention it, or not mention it in a way that was substantial enough to bring it to the agent's attention. But that at one point they did bring it up before settlement. And at that point, the listing agent should have slammed the brakes on everything and stopped everything to say, and then insisted and demanded on legal counsel. That's where the failure is. And so I don't think it was on the listing agent's responsibility to go the extra mile and to say, well, do you have anything else that could impact this? I think it's smart to do that, but I don't think it was their obligation to do that. Any other comments, questions? All right. Thanks for joining us, everybody. Appreciate it. Have a great day.
Thank you.